Following Thursday's High Court ruling that nullified the reinstatement of Sanusi Lamido as the Emir of Kano, the government of Kano State has demanded that the 15th Emir of Kano, Aminu Ado Bayero, vacate the Nasarawa Palace, where he's currently residing, as plans are underway to make major repairs there. The State Attorney General Haruna Dederi disclosed this while reacting to the ruling of the Federal High Court that nullified the reinstatement of Sanusi Lamido as the Emir of Kano. Dederi said the government has finalized plans for the property's general reconstruction and renovation, which include the immediate demolition and reconstruction of the dilapidated wall fence. This development is coming a few hours after the Federal High Court's ruling on the substantive suit, which validated the Kano Emirate Council Repeal Law 2024, but nullified all actions taken by Governor Abba Yusuf under the law.
Following this court's ruling, the Kano State government has directed the State Commissioner of Police to remove the deposed emir of the 8 metropolitan local government areas from the government property where he is trespassing, as government has already concluded arrangements for the general reconstruction and renovation of the property, including the demolition and the reconstruction of the dilapidated wall fence with immediate effect. I want to congratulate and call on the good people of Kano State to remain peaceful and celebrate the success of the people without any hitch.
All right, then, joining us on this subject, of course, is... just give us 1 second. Joining us to discuss this conversation is Dr. Mefor, a lawyer and public affairs analyst, a forensic psychologist, and fellow Abuja School of Social and Political Thought. Good morning and welcome to the morning show.
Yeah, thank you. Thank you for hosting me. A quick correction there. I'm not a lawyer. I'm a social scientist. And I think it's important.
All right, then. Thank you so much for being here. Now, let's get straight into it. I think I want to start with jurisdictional conflicts. Now, given the Supreme Court's previous ruling that, federal high courts do not have jurisdiction over chieftaincy matters, how would you interpret the decision of the Federal High Court in Kano to nullify Governor Abba Yusuf's decision? Can you elaborate, or maybe any legal precedents that might support or contradict Justice Mohammed Liman's ruling in this case?
Yeah, well, I have keenly followed what has been going on in the Kano Emirate, and the decision of the governor to reinstate Sanusi, and then the issues surrounding it, where they ousted the Emir Bayero is a contestant that is ousted, is not in order. In all this, what is important should be what you call a due process, what you call rule of law. You have to come down to the basics, the quintessence of the principle of separation of powers. We are practicing presidential democracy. And in it, you have the executive, the judiciary, and the legislature. It's the duty of the judiciary to interpret and, of course, to intervene where somebody believes that his or her right is being injured. And I think that was the measure taken by Emir Bayero when he approached the Federal High Court in Kano under the hand of A.M. Liman to ask for an order stopping the repeal of the law and the process that would see to his being removed from office and the reinstatement of Sanusi. I think the issue here is not necessarily whether there is precedence or whether the subject matter of the Federal High Court encompasses what we may call a chieftaincy matters. The issue here is an order of a Federal High Court asking the Kano State House of Assembly to hold on and let the complaint be brought before it, looked into, and then they could continue if need be. And the same thing for the Kano state government, the executive arm. But they simply ignored the order. And the order was duly served. And what you do when an order is served and you don't like the order, whether it is a matter of subject matter jurisdiction or territorial jurisdiction, what you do is to vacate the order. And you have two ways you can do that. You have to go back to that court and prevail on the judge or the magistrate to set aside the order. Or you move higher to the appeal court, even up to Supreme Court. If you do not do that, and you go on to carry out any action at variance with the content or express provision of the order by a court of competent jurisdiction in Nigeria, what you have done is an affront on the judiciary itself, an arm of government. And this is exactly what is at play. You know, so when you say that the Supreme Court had earlier ruled, yes, there may be a ruling to that effect on the fact that chieftaincy matters do not come within the purview of federal high courts. It is still not within the power of the executive, the governor, or the legislature to interpret. If you have such objection, you take it to that court or you take it to appeal. But within the period, the court order is subsisting. Whatever you do that is at variance with it will be null and void. And this is exactly what Justice Liman has just done. He has said that, look, contrary to my order, you went on ahead and reinstated Sanusi. And because you put his restatement on nothing, is void. And that is the summary of what has happened. So it is not even whether the order of Justice Liman of the Federal High Court, Kano, is valid or not. The person that will determine whether the order is valid, whether it should subsist, should be the Court of Appeal. It's not the governor of Kano. But the governor of Kano ignored the order. He went on ahead. The Kano State House of Assembly also ignored the order and went on ahead to enact the law, which is not in contention. So the order saying that all the actions taken against the order remain voided, it has very serious implication. It's not saying that even the restatement of Sanusi is invalid. In other words, as we speak, Sanusi is not the Emir of Kano. I don't know if you get my point.
Well, Dr. Mefor, we're actually trying to get your point, and I don't want to trumpet what others are saying, but many lawyers, as you are aware, are saying that the judgment, the ruling itself, is a bit confusing. And these are senior lawyers saying so. So when you ask, do we get what you are saying? Yes, in a way we do, but then we would like you to further unpack it. When you say that by the judgment of Justice Liman, Emir Sanusi, as of today, is not the Emir. Who therefore is the Emir? Is the ruling clear on that, or do we have a void until the appeal court comes, to the rescue?
Now, you see, it depends on where you are standing and where you are coming from. Yes, senior lawyers can go on and say whatever. We have seen their interpretations of many things. For example, they just concluded the presidential election in Nigeria. We saw senior advocates of Nigeria arguing from a different sides of the divide. And at the end of the day, we all saw what played out. What I am saying is, if you read the order of Justice Liman, it says, revert to status quo ante. In Latin, ante is before. That's the word for before. So when you say status quo ante, it means revert to the position of things before the matter was brought before me. And before the matter was brought before Justice Liman, Sanusi was not the emir. So if you revert, if you implement the order of Liman to the letter, you go back to the point where the matter was brought before Justice Liman. That is status quo ante, and that's what the order says. So if you have to go back to that, it means that as at the time the matter was brought before Liman, Sanusi was not restated. So my own understanding, very basic understanding, and it is founded on logic, is that Liman's order is go back to status quo ante, and the interpretation is clear. Go back to where you were before the matter came before me. And it is basic English. It is not subject to any ambiguous interpretation. Go back to where you were before the matter came before me. And where was the matter? What was the status of the Kano Emirate? By the time the matter was brought before Justice Liman, it was Bayero that was the emir. And that is where it should stand today, as far as I am concerned.
Okay, so let's talk about, the implications that a ruling like this, or even the back and forth of this particular case has when we look at the autonomy and the influence of traditional institutions in Nigeria, particularly in the Emirate system. Do you see this judgment affecting, the political dynamics in Kano, especially between the state government and traditional institutions?
Your question is very fundamental. Look, as we speak, under our constitution, the subsisting 1999 constitution, even as amended, and the presidential democracy, the traditional rulers have no role at all, as far as I am concerned. So they are just there as what you may call, should I say, vestiges of our civilization. And that is why we say they are the custodians of a tradition and culture. That is the highest you can go. Do you know that technically a traditional ruler, whether first class or no class, is a civil servant under the chairman of his local government? He's a civil servant because they are salaried. They are on salary. That is it. And they are employed under the local government system. That's what the law says. So, so if you look at it, you discover that this has brought to the fore once more the question of what ought to be the role of traditional rulers in our own democracy. The way it is at the moment does not in any way provide any clear role for the traditional institution. That's where the problem is. And that was partly why some of us were not happy when Sanusi even accepted to go to become the Emir of Kano. Because Sanusi, that I know, is an asset to the country. Cannot be tucked away in Kano under a local government chairman or even under a governor. Sanusi is an activist. Sanusi is an intellectual. Sanusi is not the person that will occupy a subdued role where he will not even be able to express himself. Look at the reason why he was removed in the first place. It was because he was advising that there was need to do something about the Almajiri system. And Governor Ganduje, as he was then, took offense, took exception to that, and removed him. That was what happened. And now his coming is even more, his return, his restatement is even more controversial. Because in attempt by the governor of Kano State to reinstate him, based on his campaign promises, because I recall that the governor, while campaigning, said he was going to restate Sanusi if he won. So what he is trying to do is to fulfill that campaign promise. I do not have any problem with that, but follow the due process of the law. You cannot bring back Sanusi without following due process of the law. And that is what I believe has really brought us to this impasse. There is no need for it. What is the rush? Follow the law. If the law says that he would come back, he comes back. If the law says that he wouldn't come back and shouldn't come back, so be it. But to go on ahead and reinstate him against a subsisting order is something that is a direct invitation to anarchy. Kano is a very volatile place. You don't take such actions because as you do so, you are creating two camps, one for Bayero, one for Sanusi. And they can come in direct confrontational impact. And at the end of the day, the polity is going to be the worse for it. So your question regarding the role of traditional rulers and what has transpired in Kano is very clear that the traditional rulers are under the political authority. And they cannot exercise powers beyond what is allocated to them by the governor of the state where they operate. Any attempt to go outside those boundaries will become a problem to themselves, to the polity generally, because you cannot have two captains in one ship. There is a governor. The governor is the one who is the political head of the state. Any other traditional ruler, no matter how powerful you are, comes under the governor and he said dictates. And this is what it is. So we need to learn from what has happened in Kano. And it's not only in Kano, it has happened around. Recently, something like that happened also in Kogi under Bello, and here and there, you will see a number of traditional rulers being ignominiously, deposed for coming in direct conflict with the political authorities of their states. So it's not good for the polity. And I think that the ongoing constitutional amendment should look into the role of traditional institutions. Give the rules or leave them out completely, if you don't want to give them any clear rules. I mean,
you speak about, you said something, and it's just a quick follow-up before my colleague comes in about, what's the rush? And when we talk about the extent of a state governor's authority in reinstating or deposing traditional rulers, when Governor Abdullahi Ganduje dethroned Mohammed Sanusi II as the Emir of Kano, what we saw was an immediate removal where he stepped down. So in his position as the governor, we were seeing Abba Yusuf saying that, okay, this is who is going to become the next emir. Isn't that a precedent that was already set that should be followed through and through when we think about the extent of the governor's authority in picking these traditional rulers?
That's where the problem is, impunity. That it happened under Ganduje and Sanusi didn't protest it doesn't make it right. You follow a process. You must follow a process. And if there is no dissension, there is no violation. But in this case, there was dissension coming from Bayero. Bayero said no, that this whole process is a charade, and they contested it in court. And Justice Liman said, wait, let's look at this complaint. If the governor of Kano and the Kano State House of Assembly believed that the action of Justice Liman was ultra-virus, all they needed to do was to appear before his court and tell him, look, you don't have the jurisdiction to look into this matter. Or they move up to the Court of Appeal to vacate the order, then you go on with what you want to do. In fact, by restating Sanusi against the subsisting order is even endangering the chances of Sanusi returning. Because the challenge is now moving up, and you can be sure that it will get to Supreme Court. Nobody knows when that will be disposed of. It could be in the next 3 years, 5 years, and things remain the way they are. Who is the worst for it? It's the Kano people, the good people of Kano State, that need anemia, that need peace and tranquility. The government of Kano that should even focus on the delivery of dividends of democracy. These are primary things that must concern all the people who consider themselves stakeholders in these impasse. And let me quickly also add that you see the issue of rush, it was swift under Ganduje, and the governor of today wanted to be as swift as Ganduje also. But do not forget that during Ganduje, there was a commission, there was an investigation into the allegations against Sanusi, and it was validated through some process. So it may not be as swift as you have really defined it. But what I consider as rush here is restating Sanusi against a subsisting and valid court order. And why I say valid, because it has not been set aside. If the order was considered invalid by the governor, by the state House of Assembly, they should have invalidated it by getting the Justice Liman to rescind the order, or they move a notch higher to Court of Appeal, even to the Supreme Court, to remove the order. You see, let me draw one fundamental line here. An order, no matter how invalid in our eyes it may be, remains an order until it is set aside. It is like a law. A law may be inhuman, a law may be obnoxious, but it remains a law until you set it aside. And that is the point I am making here. The order wasn't set aside, and that is why Justice Liman invalidated every action taken against the order. So that's it.
All right, Doctor. Two questions very quickly. First is to get your clarification on the aspect of jurisdiction. Does a federal high court, have jurisdiction implicitly over this matter? I know that Mr. Femi Falana SAN also made some useful submissions on this. What will be your own thoughts? Because at the end of the day, people will say that the prayers that the deposed emir sought, was about his human rights, not necessarily about the Emirate tussle itself. And then secondly, I like the fact that you brought the political implications of all this. Will you say that history is, in some dramatic way, repeating itself, given what happened in the early 1980s when Abubakar Rimi was the governor of Kano State, and he also tried, to create 5 emirates, thereby trying to reduce the import and the essence and the impact of the Kano Emirate. And you know that the emir at that time was not deposed; he was suspended. But of course, the implication was that he led to a huge riot for which Abubakar Rimi never recovered politically. And of course, when Bakin Zuwo replaced him in 1983, he returned the Kano Emirate to its glorious import. Do you think that that's what we are witnessing now, a report of history? And how do you think that interference from governors and from political parties will impact on what we are currently witnessing in Kano State?
Yes, certainly. Let's start with the first, the issue of subject matter jurisdiction. Whether the actions of Justice Liman concerning the chieftaincy matters in Kano, fell or falls within the purview of it will subject matters of a federal high court. It may not, but that is again not the issue here. If the issue of chieftaincy matters, never fell within the purview or contemplation of the actions that should be taken by federal high courts, all you need to do is to draw attention of the judge to it. That wasn't done. And even if you did, and the judge still assumes jurisdiction, you move to Court of Appeal and ultimately to Supreme Court. You see, the wheel of justice may grind slowly, but it will arrive at the destination. You don't need to rush, because if you rush, you will be assuming the what you may call the job of the judiciary. When the executive arm in Kano, under the governor, decided to go on and they reinstate Sanusi, they did that at variance with the express provisions of the order validly issued by Justice Liman. And that is what I want us to dwell on as the issue. Because as we speak now, despite what the Supreme Court may have ruled in the past, it's not part of our law yet. And don't forget, no two cases are exactly the same. You may not be privy to the entire prayers and pleas that were actually taken to Justice Liman. Until you read the whole, you may not know precisely why Justice Liman assumed jurisdiction. So his assumption of jurisdiction could be right, it could be wrong, and it is not for us or the executive arm nor the legislature to validate the order or the assumption of subject matter jurisdiction by Justice Liman. It is still his court or the appellate court. And if there are actions that a judge may commit, and you may consider such actions to be what you may call judicial rascality. That is why you have the National Judicial Council. Many judges have been removed because of it. So it's not as if there are no checks and balances. We have checks and balances in the system. It's just that most of these rules, regulations, checks and balances have been observed in breach. And we cannot take because of the actions of some judges you may consider belligerent and throw away the entire judiciary. We can't afford it because Nigeria is a nation built on law. Nigeria is a colonial construction, and after independence, the subsisting and succeeding constitutions have revalidated the Constitution of Nigeria as a country under law. And we are practicing presidential democracy. You must allow the three arms of government to do their work, and none should assume the role of the other, as has happened in Kano. Because when you wish away the order of a court, you have actually assumed that either the arm of government does not exist or that you too can do the work. Then on the second issue you raised concerning history repeating itself, I agree with you. And of course, that is why I warned earlier that you see, Kano is a very volatile place. Kano has its own psychology, and nobody should take their silence for weakness, because they can erupt. And that is why we must allow the rule of law to take its course. We must. The action of the governor asking the police to evict Bayero from the Nasarawa mini palace, for me, is overreaching. It's uncalled for. The issue is before the court. And the Bayero has even left the main palace. He's staying somewhere else, not as befitting as where he should be or where he was before he traveled and this issue happened. Now, why don't you allow the sleeping dog to lie and allow the judiciary to do its work and tell Bayero or Sanusi that you are or you are no more? Once that is done, everything will be settled if it is eventually resolved in favor of Sanusi. Bayero will give way, and if it is resolved in favor of Bayero, I believe Sanusi would also give way. We do not need to continue to heat up the polity. Heating up the polity here means that the repeal, the law that has been repealed by the House of Assembly, Kano, yes, I agree, they have the right and the powers to repeal or make new laws. There's no doubt about that. But again, it's not for you and I to decide the validity of that repeal. the validity of the repeal will have to be affirmed by the court. And once it is affirmed by the court, because it is being challenged, what will happen is that the implementation of the law will be the next thing. And before the affirmation of that law, implementation of it will be putting the cart before the horse. It's very wrong. You have to, because if there was no contest, if Emir Bayero did not contest it, there wouldn't be we wouldn't be here. If, for example, he returned to the country and headed to Wukari or Borno or wherever, nobody will be talking about this here. But he believed that his rights were actually trampled upon. You don't shave somebody's head in his absence. Nobody is aware that Emir Bayero was queried for any infractions. So the issue of his fundamental human rights can also extend to the fact that he is querying his removal itself. Why should he be removed? Even if you repeal the law, does that automatically mean that he should leave office? Right. Since he never actually committed any infractions? So these are some of the things we need to unpack for us to come to grips with what this whole impasse is all about. Right, and like I said, so just before the last thing I want to say,
we're running out of time.
just one word.
Unfortunately, we're running out of time. Okay, just one more thing.
I want to thank the Nigeria Police Force for what they are doing in Kano, for what they are doing in Rivers. Right. Without them, there would have been total anarchy.
Definitely. Thank you so much, Dr. Mefor, forensic psychologist, public intellectual, and public affairs analyst. We appreciate your time and analysis this morning on The Morning Show.